What's the guard's number out there? Fire department, security, marshal, clerk. Oh,
Good morning, Your Honors. Your Honors, the opposing attorney is not here.
Really?
And there's a brief matter I plan on addressing this morning. The marshal's cleared it. I have an exhibit, and I wanted to know if it would be okay with the court.
No. No, unless you have consent from the other side.
Yes, Your Honor, I understand.
First of all, let's see. This is LAVALLIERE versus HSBC Bank.
How do you say it, LAVALLIERE?
I say LAVALLIERE.
LAVALLIERE, okay.
And who do you represent?
Your Honor, Stephen Kramer here on behalf of the appellant, the homeowners of LAVALLIERE.
Okay. And the bank's not here?
The bank is not here, Your Honor.
Did they call you? Have you heard from them?
I've not heard any. I checked in the clerk's office to see if there was any update on the
Must
file.
be feeling pretty good now that you don't have an opponent, huh?
I wouldn't go that far. I think I just, Judge Cohen just let me know my
Hold on, let me
singing.
start the clock. All right, now you're on the clock.
Mr. Kramer, let me ask you something. What about, there's a stipulation in the record at 51?
Yes, Your Honor.
What effect does that have, you know?
Your Honor, we think that has a...
No one mentioned it.
Yes, Your Honor. It's there's 37 sworn statements relating to the negotiations and the modifications.
But tell me about the stipulation.
Yes, Your Honor. That stipulation...
Because after the default was entered,
yes, Your Honor.
The bank stipulates with at least one of your clients, the hubby, I believe, David, you know, and says, you know, we agree to this. You're the holder of the note, the owner of the note, and blah, 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 and I'm going to pay you this much money on these dates, and if I don't, you're entitled to just file an affidavit and get a default or a final judgment.
Well, Your Honor...
Does that have any effect at all?
It does. It has an effect on the case. Part of what we're seeking today is a reversal of the denial of the motion to set aside the default and the subsequent reversal of the denial of the motion to vacate the default summary judgment.
Well, tell me what you think the stipulation does.
Well, the stipulation, the case is filed on October 24th, 2008.
Right?
The stipulation is entered into by the parties on December 8th, 2008.
Okay.
And it's signed... This is before the default is entered.
I think it's after.
Your Honor, the record shows...
Not the default final, but there was a default, clerk's default.
Your Honor, the default was entered actually on December 10th. So the stipulation agreement is signed. The parties are negotiating. Mr. LAVALLIERE and the plaintiff's attorney signed the stipulation agreement on December 8th. And this is...
January 8th, 2009.
That's when the court stamped it, I think.
That's exactly right. The agreement's actually signed, and this is the record at 50...
It was approved by the court, correct?
It was not approved by the court. This is in the record at 51 to 60. It's signed by the parties, one date, two signatures, December 8th, 2008. And this is an example of the negotiations between the parties. The motion for default is actually filed on December 10th, 2008. So this is 2 days later. And what's troubling about this is, on one hand, the lender is going, we want to negotiate with you, we want to work with you.
It looks like that, let's say they made an agreement, right?
Yes, Your Honor.
And who defaulted on it? I would guess Mr. LAVALLIERE.
Mr. LAVALLIERE.
Payments.
Well, that's another issue. This is a case about a homeowner who didn't default on the mortgage. And this is by the bank's own admissions, that there was no default on the mortgage prior to the filing of the case. So what the homeowners are saying is, we made the payments. And then, this is a homeowner who didn't default on the mortgage, who's now been defaulted by the court and is going to lose her house. So the stipulation agreement's entered into on December 8th. The motion for default is filed on December 10th, 2008, and the actual clerk's default is on December 15th. So again, troubling on one hand. We're negotiating with you, and then we're going to go ahead and file this motion for default. And what's interesting about the motion for default is that there's no certificate of service. So Rule 1.080A states that paper should be served, and there's no service. And what's interesting, the clerk's default is on the same page. And this is in the record at 36. And there's no certificate of service there either. So you have a stipulation agreement entered into, you have a default 2 days after, and then 5 days after that the clerk enters the default. And what's also troubling is that the plaintiff who's in possession of the stipulation agreement, which is executed on December 8th, doesn't file it till January 8th, a month later. And so basically they sit on this thing. They've got a signed stipulation, and if it had been filed timely, if it had been filed on December 8th, then there couldn't have been a default because it's signed by Mr. LAVALLIERE. So it would have been a paper submitted to the court. Now, I mentioned that this is an issue about a homeowner who didn't default on the mortgage and was sued for foreclosure. And this is by the bank's own admissions.
Counsel, hold on. On the second page of this stipulation, it says, the parties agree that the loan is in default as a result of defendant's failure to pay amounts due and owing thereunder.
I understand that may say that.
That's what your client stipulated to.
Agreed, Your Honor, but there's some conflicting information and facts here. The first off,
Why would there be any facts to be considered beyond the stipulation?
Well, there's sworn
Your client
facts.
says, we didn't pay the mortgage.
I mean, that kind of,
there are sworn facts, Your Honor. First off, the plaintiff, in their amended motion for summary judgment, states that the plaintiff, that the homeowner, or I'm sorry, that the plaintiff has not been paid January 1 and all subsequent payments. Why does that matter? Because the case is filed in October. So this is the bank saying the default accrues in January. This is in their motion for summary judgment. Also in paragraph 5 of their amended affidavit of indebtedness, they state the same thing. The payment due on January 1st under the note and mortgage was not timely made and thereby in default. And this is in the record at 62 to 72. So they are acknowledging that payments were made. There was no basis for the lawsuit because the homeowner wasn't in default at the time of the suit.
Why would he sign a document that says, I'm in default on the loan and mortgage?
Well, that's a very good question. What we have to understand...
Do you deny the existence of the stipulation?
Absolutely
Do
not,
you
Your
deny
Honor.
that your client signed it?
No, Your Honor.
all right, let me ask you this. It looked like there were payments due on the stipulation. And did he default on the payment that was due January 1? Wasn't there one due January 1 or something?
Your Honor...
Is that the payment they're talking about in their, when they file the affidavit for, a judgment, a final judgment, basically? Was it based on the stipulation?
No, Your Honor, there's no indication of that. Further, the homeowners have claimed and they've sworn that they continued to make the required mortgage payments. And they're not addressing the stipulation. The required mortgage payments until February 2009. So they're saying we made all the payments. And there's no delineation there. To address your question, Judge Monaco, why would they sign this? Well, these are homeowners. These are common people. They're representing themselves. They are pro se. And in addition, they were relying on representations from the lender. And one of those representations, which they swore to on the record at 105 to 112, was that the plaintiff made representations, quote, that I did not need to retain an attorney for the pending foreclosure. They also said, the plaintiff also, and they've sworn to this, that the plaintiff made representations that I shouldn't worry about the pending foreclosure. Why would they sign that indeed? And what's also troubling about this situation is you've got a pro se party who's now been told they don't need an attorney, told they don't need to worry about the foreclosure, who is reading the stipulation.
If you signed the stipulation and made the payments, you wouldn't have to worry about the foreclosure.
Well, and they've taken that position as well, Your Honor. They did make the payments as far as they've sworn, and there's no conflicting sworn statements or evidence negating that.
I thought they were making late payments and the bank quit accepting them.
Your Honor, that really deals with prior to the case being filed. And what they've said there, and this goes to the meritorious defenses in the case, is they had a course of dealing with the bank. They made late payments from time to time. The bank accepted them, and it was never an issue.
Excuse me, through the stipulation, didn't you waive all your defenses?
No, Your Honor, the defenses weren't waived. There were counterclaims that were waived within the stipulation, but that doesn't address affirmative defenses.
Well, it says, paragraph 8, rights, liabilities, and waiver of defenses. And the appellant specifically waive any and all defenses that may have related to the note and mortgage. Paragraph 8.
Yeah.
Just 1 second, Your Honor, please.
Leases, discharge, and covenants not to sue Wilshire.
Appellant specifically, well, it says appellants waive any and all defenses that may have related to the note and mortgage. I mean, that's what it says. Each party acknowledges that the other has asserted rights and has denied liabilities that are finally settled by this agreement, and any and all defenses that they have related to the note and mortgage are waived.
Well, there's a few issues here, Your Honor. First off, this agreement was only signed by one of the parties.
Does that, I mean, you don't have any defenses after that, do you?
I believe so, Your Honor. I believe that the course of dealing within the case itself presents issues. The defendants...
Of course, what does that mean within the case itself? I mean,
well, the homeowners have sworn that that they continue to make payments due under the stipulation. And they entered in this agreement under certain representations from the lender that they were going to work with them in good faith.
Well, the trial court didn't think much of those representations, did it?
The trial court did not, Your Honor.
Right.
And really, the crux of this goes to the excusable neglect, and that was the basis for this.
So what we're talking about is when there's a waiver of any and all defenses that may have related to the note and mortgage, are there defenses that you want to assert that are not related to the note and mortgage? And if there are defenses, how is that relevant to this case?
Well, there are defenses, Your Honor. The defenses are that the payments were made under the mortgage, that there is a fraud inducement element here, which is...
Were all the payments made under the stipulation? I think, to me, that's a critical issue.
Yes, Your Honor. The stipulation calls for 3 payments. In attachment 1, it says payment due date 12/08, 10509, and 20509. And there is an allegation, and it's sworn by the homeowners that they continue to make the mortgage payments required under the mortgage until February 2009.
No, but the payments are supposed to be made under the stipulation now, once the stipulation was signed. If you don't make the payments under the stipulation, then the bank can come in and get its default, and it's judgment.
We take the position, Your Honor, that
Were the payments made pursuant to the stipulation or not? Yes or no?
the homeowners have sworn that they made the required payments to the mortgage company, and required is the exact language I understand.
They say they made the payments under the mortgage or under the stipulation?
I believe they've said, I believe it's been phrased both ways. There's 37 of the sworn statements.
37.
37. Homeowners have sworn that they made payments until February 2009 as required in the stipulation. They don't address the stipulation directly, but they say as required. They also say, and
Is it
it's
said as required in the stipulation or as required?
as required. The homeowners have also sworn that they were working in good faith to modify their mortgage with the lender. And this is again in the record in the motions to vacate the defaults, both of them, at paragraph 1. The crux here is, as well, that the only one of the
in order to set aside a final judgment entered on default, you have to establish meritorious defenses, among other things. And I'm having a difficult time with that when it looks as though all of that was waived in the stipulation.
Your Honor, first,
And I'm trying to ascertain what your meritorious defense is that would not have been covered by that stipulation, and I certainly don't see it.
well, first I'd state, Your Honor, that only one of the parties signed the stipulation. That was Mr. LAVALLIERE.
So it needs to be binding on him, correct?
It would be binding on him, but not on his wife, who also has an interest in the property and is also a signatory in the mortgage. So with respect to the stipulation, it may apply to Mr. LAVALLIERE, but not to the wife.
Let's get back to the stipulation then. Where's your meritorious defense? And I just don't see it.
Well, the meritorious defense is that the homeowners have claimed that they made their payments under the stipulation, that the lender has basically induced them to sign a stipulation by telling them they do not need an attorney. So they told them, you don't need an attorney, go ahead and sign the stipulation, everything's going to be fine, we're going to work with you, we're not going to pursue...
How did they make the payments?
That's not on the record, Your Honor, I'm sorry.
It's not in the record?
It's not on the record how they made the payments.
And there's no documentation of the payments?
There's no documentation of the payments. There's only sworn allegations which are irrefuted by the lender. So...
Well, the lender said they did make the payment. Didn't they?
That would be a reputation.
The lenders actually said that payments were made until January 2009. That's what's been acknowledged. So there is a month that's at issue there. However, there's no necessary allegation refuting that. But again, back to a fraud and the inducement argument. The lender says you don't need an attorney, go ahead and sign this, we're going to work with you. These are common people, they're acting pro se.
It was you got defaulted, so you never got a chance. But you didn't raise fraud and the inducement, did you?
Well, actually, Your Honor...
You didn't address the thing in the brief.
Well, this is with respect to the stipulation. If it comes to a point where we're arguing about whether the stipulation is valid and enforceable,
right,
then this is an issue that would develop.
As I said, no one said anything about the stipulation in either brief that I could see. Maybe I missed it, but...
Your Honor, there's nothing... This is sometimes it takes a lot of work to find the rifle shot, and there's a lot of moving parts here.
Who executed the note? Was it just the defendant, Mr. LAVALLIERE, or did his wife execute it as well?
Mr. LAVALLIERE is the only signatory in the note. However, However,
Why, so what
That might be,
difference does
that's
it
why they
make?
only had him on the stipulation.
that would make sense, Your Honor.
So what difference does it make whether it applies to his wife? I mean, he's the
So
only one that
she's down
signed
by
it.
that, I mean, as far as,
Was she owner of the property as well?
She was an owner of the property and also listed
He's
in
the
the
only one that
mortgage.
signed the.
did they take title as joint, as tenants by the entirety?
Yes, Your Honor.
But
So
the mortgage- but the mortgage note was just him.
Yes, Your Honor.
She signed, did she join in the mortgage, I hope?
She's also a signatory in the mortgage.
But as to the note, he was the only one that signed the note, right?
As to the note, he was the only one that signed the note, but she still has an ownership interest in the property. But there's a few points that I'd like to point out here about the agreement itself. One is that the agreement was procured by fraud and inducement because there were representations that and they sworn that the lender that the lender stated they were going to work with him in good faith, that they made payments to the lender based on those representations, that the lender told them not to get an attorney. They've sworn that they made the payments. They've sworn that they replied to every inquiry for information from the lender. And we believe this presents a problem with the stipulation itself. Further, the stipulation was never adopted by the court. So it's a raw stipulation out there. There was a motion filed that was never executed upon. Further,
If the mortgage secures the note, and the note is the document that is actually being secured by the mortgage, and the mortgage essentially secures the note, and the husband was the only one that signed the note, what difference does it make whether the wife executed the stipulation or not?
well, the husband can't divest the wife of ownership in the property.
Well, what we're talking about in terms of a judgment rendered on the note.
Your Honor,
As far as the judgment is concerned, it may be a judgment of foreclosure, but the judgment concerning the note would not be affected, would it?
concerning the note and liability under the note, that's true, but the note is only the promise to pay. It is the mortgage that is a security interest in the property.
They don't have to do anything with the mortgage. If you have a judgment saying that the note is due, and you have a judgment saying that this
In other
money
words,
is
the
due
wife
under
had
the,
no obligation
they don't
to
have to
make
do
anything.
anything, they don't have to do anything under the mortgage. They can take that judgment and obtain their money under the judgment any way they want to.
They could, Your Honor, if they filed an action on the note, which is separate and distinct from a
Well,
foreclosure.
an action on a foreclosure is an action on the note and the mortgage too, isn't it?
Exactly, Your Honor. However, there are cases where lenders will come in and they will file solely an action on the note, and that is distinctly different because the mortgage is foreclosing on the interest of ownership based on the lien. She had to sign the mortgage because she has a homestead interest in the property, she has an ownership interest in the property, and she has a right to assert defenses, even if they may not be relating to payment due under the note and debts under the note.
What defenses would she have as to the note that she didn't even sign?
Well, Your Honor, she would be able
What would be her
to...
defenses as, pardon?
She'd be able to raise any defenses regarding payment under the mortgage, because basically...
No obligation.
It's not payment under the mortgage.
It's the
payment
payment,
under
I'm
the
talking
note.
about payment under the note.
That's what it is.
All the bank does is foreclose to secure their payment under the note. If they get even in a foreclosure action, if the foreclosure judgment says that the note is due and that the judgment says that they owe the money under the note, the bank doesn't have to do anything with the property if they don't want to. If there's other property that the bank can use to satisfy the judgment pertaining to the note, they can do that as well. So the fact that he is the only one that signed the note, what defenses would she have that relates to the note when she didn't even bother to sign the note in the first place?
Your Honor, respectfully, the mortgage foreclosure is an action to foreclose on the mortgage. The property is sold because it's an action to collect monies. The property is sold, and the monies are distributed either surplus or the deficiency to the lien holders in order. The property must be foreclosed under the mortgage because she has an ownership interest in the property. And as with respect to the note, that only deals with the debt obligation. The mortgage itself is what secures...
The mortgage is what secures the debt obligation. The mortgage is what secures that note.
But the mortgage confers certain rights on both signers of the mortgage. The mortgagor has rights, as does the mortgagee. One of the defenses that she could raise is a failure to give notice, and this is sworn in the affidavit. I didn't receive a notice of default relating to the mortgage. Basically, the bank never told her that she was in default before they filed a lawsuit. That is not only That is not only a notice issue, it's also a condition precedent. Paragraph 22 of the mortgage states that the mortgagee has an obligation to serve notice of the default before filing a lawsuit.
Did she file a motion to set aside the clerk's default that was entered before the stipulation was signed?
She did not, Your Honor.
Well, because
then what-
the stipulation was signed before the default, which is what you said.
Yes, Your Honor.
Well, there was a default that was entered by the clerk, right?
Yes, Your Honor.
And the stipulation you said was entered before the default.
Yes, the default was entered, it was unserved.
Well, the default was against who?
The default was against both parties.
But she
Both homeowners.
didn't move to set the default aside as to her, did she?
She did.
Well, then the stipulation only applies to him, right?
But the stipulation isn't the sole basis of excusable neglect. Let me address one point, Your Honor. If there was no basis to ever bring the action because the mortgage and the note were current at the bringing of the action, which is uncontested, that they were making payments at this point, then there was no basis to bring the action, that there's no basis for the stipulation agreement.
You would concede then that she didn't move to set aside the default, and so as to her, that default still exists, right?
May I answer the question, Your Honor?
But as to the stipulation, he stipulated, because he was the only one that signed the note, the default will be set aside and that the payments will be made. He didn't make the payments, and so the bank pursued the foreclosure action. So what difference does it make then?
Answer this question, then your time is up.
Yes, Your Honor. The stipulation agreement is not the sole basis for the excusable neglect.
Okay.
Both parties are acting pro se. The stipulation agreement's entered. Neither the motion for default nor the default is served on the parties. 6 months later, in June, there's an affidavit of noncompliance.
If we say that we just reject your argument about the excusable neglect and say there is no excusable neglect, then what?
Then we're done. That's one of the prongs. May I finish?
No, we've gone over your time already. Thank you very much.
Thank you.
Thank you, Your Honor.
We'll hear from the bank.
I'd love to hear from the bank.